Thank you. Mr. Brown, you have a right to make a statement prior to sentencing.
He does not wish to speak, Your Honor.
Is that correct? All right. The defendant said no. The record should reflect the court did give Mr. Brown an opportunity to make a statement. Before I start my sentencing remarks, I just want to put on the record a few statements. First of all, I know he has the homicide issue in Illinois, but I'm going to sentence him for the crimes that he was convicted here in Wisconsin, what the jury found him guilty of. The next statement is he had pending charges that were mentioned in the pre-sentence, but all those charges were dismissed by Racine County. They're all dismissed. The other statement I want to make, I'm not going to hold it against Mr. Brown that he had a jury trial. Obviously, he has a right to a jury trial. And the last statement I want to make before I proceed with my, I'm not going to punish him for being somebody from out of state. We all travel to other states. Obviously, you commit a crime, you get punished for the crime. You don't get punished because you are not a resident of this state. So with all those statements, I'll start my sentencing. First of all, obviously, I have to look at all the charges. And there's a lot of serious charges here. The defendant, after the jury trial, was convicted of all 9 counts. And I will go through each one for severity and gravity purposes. Count 1 is first-degree reckless endangering safety by use of a dangerous weapon. That is a Class F felony. He has the weapons enhancer, the dangerous weapon. His initial confinement on that one could be 12.5 years with 5 years extended supervision, $25,000 fine, or up to 7.5 years of probation. Count 2, again, is another first-degree reckless endangering safety by use of a dangerous weapon. Again, he could receive 12.5 years initial confinement, 5 years extended supervision, and a $25,000 fine. Count 3 is another first-degree reckless endangering safety by use of a dangerous weapon, another Class F felony, 12.5 years initial confinement, 5 years extended supervision, a $25,000 fine. Count 4 is a possession of a firearm by an out-of-state felon. That's a Class G felony in the state of Wisconsin, 5 years initial confinement, 5 years extended supervision, a $25,000 fine plus court costs. Count 5, strike a police fire animal using a dangerous weapon causing injury. That is a Class I felony. It's one of the lower felonies. The initial confinement could be 18 months with 2 years extended supervision and a $10,000 fine. Count 6, mistreatment of animals, law enforcement, use of a dangerous weapon. Again, that's a Class I felony, but the dangerous weapon enhancer is allowed on that charge. So the initial confinement for that one could be 5.5 years or 2 years extended supervision, a $10,000 fine plus court costs. Count 7, failure to comply when officers attempt to take a person into custody. That is a Class I felony, 18 months initial confinement, 2 years extended supervision, a $10,000 fine plus court costs. Count 8, drive or operate a vehicle without owner's consent using a dangerous weapon, a Class I felony with the enhancer. 5.5 years initial confinement, 2 years extended supervision, a $10,000 fine plus court costs. And finally, count 8, the attempt to escape after he had been put in the hospital for the injuries that he received. That is a Class H felony, 3 years initial confinement, 3 years extended supervision, and a $10,000 fine plus court costs.
Your Honor, I'm sorry to interrupt, but there are also use of a dangerous weapon enhancers on counts 1 through 3 that add another 5 years to each of that.
I did say 12.5 years initial confinement.
Okay. Plus the 5.
Yes, plus the 5 years extended supervision. I could have my court reporter read it back.
I'm saying there's also the additional 5 years that's increased with the use of a dangerous
I said 12.5 years initial confinement and 5 years extended supervision.
Okay, thank you.
Yeah. I didn't think there was going to be any math questions here.
And I'm terrible at math, that's why I'm a lawyer. Thank you.
What I'm trying to say is all these could be consecutive. They could all follow each other. So the defendant's facing a lot of time here, to put it bluntly. You know, and then I have the advantage of the jury trial. It's not like there was a plea here and then there's a dispute as to facts and the attorneys are arguing different scenarios. I did witness the jury trial, and it's not easy to watch videos when people are getting shot at. And what I remember from the jury trial, it happened during the day, middle of the day. It might have been the morning or afternoon, but the area where it happened, Benson's Corners, is a pretty busy intersection in the county. So it's happening during the day, and the state's absolutely correct. When you watch the videos, there's so many cars driving down Highway 50. So we have an individual who's sitting in the parking lot there, and his vehicle is disabled, and the police show up. They're in marked police vehicles. They have their uniforms on. It's not like he doesn't know the police aren't there. They turn on their lights and they're going to try to make an arrest. And the defendant, as I recall, gets out of the vehicle and starts running. And while he's running, he starts shooting. So the police didn't start this incident by shooting at the defendant. The defendant shot at the police. There's no question about that. And each officer that testified as to counts 1, 2, and 3, I remember their testimony. It's got to be scary and dangerous while you are trying to chase a defendant to see a gun being fired at you. I don't know what goes through your mind at that moment. Your family, your career, or is this going to be it? But it's not a good thing. And then we have the dog. The dog did save people's lives that day by taking a bullet to his head. And there was no reason for that. I don't know where the defendant thought he was going to go and get away. There was no way he was going to escape. So what does he do? He shoots the dog in the head. You know, and then it's always difficult for me to sit and listen to victims make their statements. It's emotional. And I heard the statement of the victim today. It's emotional because the victims, they're going to have to deal with this for the rest of their lives. They are affected. We're human beings. And his family's affected. So I take into consideration the victim's statement here. I think it's very important. And I believe under Marcy's law, it's a consideration that I have to consider at sentencing. But I also have to consider the character of the defendant. And I look at his criminal record. I'm not going to talk about his juvenile record, but his adult record starts the conviction date 2007. This incident happened in 2021, so we're about 2 years after the incident. We were finally doing the sentencing, but 2007, he's got convictions out of the state of Illinois: battery, theft, criminal damage to property, resisting, obstructing a peace officer. He got, looks like, a couple months of court supervision. 2008, he has another battery, says 60 days in the Department of Corrections. And then they mention another 2006 case, assault domestic battery, resisting a peace officer, 2 years of supervision. 2009, aggravated battery, great bodily harm, 2 years of probation. He's revoked. He's got 2 years of initial confinement in the House of Corrections. He's paroled. He's discharged. 2009, he's got another resisting a peace officer, 24 months court supervision. 2010, aggravated battery, harm, peace officer. 4 years initial confinement. He's paroled, he's discharged. 2014, he's got operating a motor vehicle under the influence, contempt of court. His license was suspended, spent some time in jail. So as to his prior record, he has a lot of criminal activity that deals with police officers. And he's been on probation, he's been to prison, he's done jail time, he's been fined. So his record is not good. Then I look at the other factors of the defendant. On page 16 of the pre-sentence, the defendant indicated to the writer that he's been to prison 4 to 6 times. I don't know if that's accurate, but I know he's been to prison previously. I already mentioned they talked about pending charges in the pre-sentence report. The ones in Racine have been dismissed. He still has the open cases in Chicago. He does have a daughter that's mentioned on page 21, indicates she's about 10 years old. He does have some employment history. He's got some education. Obviously, he has mental health issues. I have to consider that. He did have some substance abuse issues that are mentioned in the pre-sentence report. Majority of his life he spent in Cook County, Illinois. So obviously this it's not a probation case because of the serious charges and the criminal record of the defendant, but the court does have to pronounce sentence, and I have to take into consideration the factors I just went through and the statements of the victim and the severity of the charges here. So I think the first-degree reckless endangering safety charges by use of a dangerous weapon are assaultive. They're dangerous. I think they're vicious. I think they're aggravated. There is a need to protect the public for those charges. There's a need to punish the defendant, and anytime anybody shoots at a human being, I think the court system has an obligation to protect the victim and the public. There is just too much use of weapons in our society today. And the other aggravating factor here is that the crimes are committed against deputy sheriffs or police officers. They're here to protect us. And they don't need to go to a crime scene and get in a position where they will not go home. They're just trying to do their jobs. And sometimes I wonder why they do that. Their pay isn't the greatest. And they take so much abuse. And they have families. So those charges are Class F felonies for that reason. And we have the dangerous weapon enhancer. And we have 3 different victims on each one of the counts. Count 1 is Juan Avila. Count 2 is Colin Coltrip. Count 3 is Terry Tiff. They're all different people. They all were shot at. They all suffered some sort of injury. They're all separate victims. So as to count 1, to a deterrence to others, to protect the public, and the assaultive nature of those crimes. On count one, the defendant is sentenced to 12.5 years initial confinement, followed by 5 years of extended supervision. On count two, it is a consecutive sentence because I mentioned it. It's a separate victim. It's a separate crime. The initial confinement is 12.5 years, followed by 5 years of extended supervision. Count three, again, is another first-degree reckless endangering safety, another aggravated assaultive crime. And it's consecutive again. It's another victim. It's another human being that was shot at. 12.5 years initial confinement, 5 years extended supervision. It's consecutive to count two, consecutive to count one. Count four, possession of a firearm by an out-of-state felon. There's a reason for this law. You are convicted of a felony. You cannot possess a firearm for the rest of your life. I don't know how many times I've read that warning in court, and there's a very solid reason for that. We don't want felons having weapons because the chances are they're going to use them in a situation where something can happen. So those crimes are Class G felonies in the state of Wisconsin. So I consider that a serious violation of the law. So he gets 5 years initial confinement for that and 5 years extended supervision. Again, it's consecutive to three, it's consecutive to two, and it's consecutive to one. Now counts 5 and 6 deal with the shooting or the use of the weapon towards the police animal or trained dog. Unfortunately, those are Class I felonies, but that's what the law is today. And as mentioned in my previous remarks, I really believe the animal saved some human lives that day. So as to count 5, it's a Class I felony. The initial confinement is 18 months with 2 years extended supervision. Again, that's consecutive to 4, consecutive to 3, consecutive to 2, consecutive to 1. Count 6, mistreatment of animals, law enforcement, use of a dangerous weapon. Again, assaultive crime, save people's lives, aggravating. It is consecutive also because there are different elements there. That one is a Class I with the enhancer, so the initial confinement is 5.5 years, 5.5 by 2 years extended supervision. Again, it's consecutive to 5, consecutive to 4, consecutive to 3, consecutive to 2, consecutive to 1. Count 7, failure to comply with the officer's attempt to take a person into custody. Obviously, that was a chaotic situation. As to that count 7, it is a Class I felony. That is 18 months initial confinement, 2 years extended supervision. That one is concurrent to 6, 5, 4, 3, 2, and 1. Count 8, drive or operate a vehicle without owner's consent, use of a dangerous weapon. That is the taking of the vehicle that started this whole crime scene or crime action by the defendant. And there was some statements in the pre-sentence from the victim's family as to that. So I think there has to be a punishment on that one, deterrence to others. And there was also a dangerous weapon where the defendant was found guilty as to that one. So on as to count 8, that is a Class I with the enhancer, 5 years initial confinement followed by 2 years extended supervision. That one's consecutive. The 6, 5, 4, 3, 2, and 1. Count 9, that's the escape. It was a video that we watched during a trial where the defendant is being treated at the hospital for the injuries that he received. So what does he do? He tries to run away from the hospital when they're trying to help him. I think that's aggravating. It's a Class H felony. The initial confinement is 3 years initial, 3 years extended supervision. That is consecutive to 8, 6, 5, 4, 3, 2, and 1. The only concurrent sentence is count 7. I also have to tell the defendant he cannot possess a firearm for the rest of his life. He cannot vote in an election until his civil rights are restored. I also have to inform the defendant while on supervision, he'll obey all the rules and regulations of his agent, pay his supervision fees, not to possess or consume any alcohol beverages or have any alcohol beverages within his residence. He's not going to be any taverns or premises licensed for the sale of intoxicating beverages, except restaurants and grocery stores. He's not going to possess or consume any controlled substances set by prescription, submit voluntarily to any random tests of blood, breath, and urine, participate in counseling as deemed appropriate by his agent, act research or employment, be employed or attend an educational institution or vocational training program. I'm not going to fine him. He does have to pay the DNA surcharge on each conviction. Provide the sample. He has credit for 747 days. He's also eligible per the pre-sentence for both programs in the prison system. Did I miss anything from the state?
I don't believe so, Your Honor.
Miss anything from the defense?
I don't believe so, no.
You can do the rights of appeal right there, and we'll give you all the paperwork.
We've already discussed
All
it,
right,
so.
just wait for the paperwork then from the clerk, okay?
Thank you.
Thank you.
I guess, Your Honor, in terms of count 9, you indicated 3 years of initial confinement and 3 years of extended supervision.
Right.
I guess based on the pre-sentence investigation, the maximum term of initial confinement they list for that is 1.5 years.
On count 9, it's a Class H.
Okay, all right, thank you.
Anything else?
No.
All right, thank you.
Thank you.
There's nothing else we need. We can take the paperwork later.
It's up to you guys. Can somebody else bring over the paperwork? That's fine. We've got other in custodies this morning.
Judge. No contact.
That will never happen.
And the credit is on.
7, it's on.
Oh,